most people have statute books, which, by the way, for anyone wondering where new statute books, there were some updates in the law. As you might have known, there was a fight over the Arizona budget, and things didn't get finalized at the legislature. And so we will be printing new statute books and getting those distributed after we get those finalized. But we didn't know exactly what was going to be in the statute books till very recently. Because I know there's been a lot of questions from people asking about statute books and when we were going to get new ones. Oops, I guess I could go to the actual. Well, it's right at noon. How many people do we have here, Terry? You're on mute, Terry.
Ooh, sorry. I was saying right now we have 15. You might want to give it a minute.
Yeah.
16. I'm letting someone else in.
All right. The Arizona statute is for fiduciary duty is 14-13115. And they also say a duty of confidentiality, which I think is kind of part of the duty of
Care.
Loyalty.
Well, both. It's both. It's part of both fiduciary duties.
Yeah, I agree. Yeah.
Again, like I think like our clients get so focused on the statute, but at the end of the day, I think a court's just going to hold them probably to the common law and do a hybrid business judgment rule.
Yeah. Well, all the statute says is, well, not all it says, but the legal duty imposed upon a fiduciary is the duty of care, the duty of loyalty, and the duty of confidentiality. It doesn't define what those things are.
Terry, how many people do we have just telephone call in only?
Let's see. One.
At least one.
Yeah. So far, just one.
For those of you that have joined us with your computer, there's a handout that Terry put in the chat that says 10 things I hate about you. It's an overview, hypothetical that we'll be discussing today in the seminar. It reads like a very bad law school question, like a final exam, that you would get the set of facts, and you would need to identify what laws are relevant and analyze based on these facts. So we try to do something different today. I don't know if you all know the function of how to raise your hand. I like that function. Does anybody has anybody here actually watched the movie 10 Things I Hate About You? I see no shaking heads. It's a teen angst movie. And after you have the seminar, I encourage you to go watch it, just because it's a cute little stupid comedy. And I've based all of our hypothetical board members on this movie. In fact, every picture on my PowerPoint has been stolen for that movie. So I'll give you that disclaimer right now. So I've loosely based our hypothetical board members in Padua Homeowners Association from the movie. I think it was Padua, Washington, Padua High School, where that movie was set. So if you like Heath Ledger and Julia Stiles, and there's a couple of other guys in there that are recognizable, it's a cute little movie. And I had a lot of fun doing the R&D for this seminar and preparing for it and playing off of their personalities in the movie to make my hypothetical board members. Not that every board typically has the same cast of actors. In fact, I hope that you don't have the same cast of actors for some of the bad behavior that we're going to talk about. But anyway, the handout in the chat that Terry has distributed has the hypothetical in there and what we'll be talking about, and in the slides to discuss the different hypothetical people. So those of you just joining us, I'm Christina Morgan. I'm a partner at Weil Fotheringham, and I'm presenting today with Rob Berry. Say hi, Rob. Rob just raised his hand.
Hey.
Rob's been an HOA attorney a little bit longer than I have been. We both have handled a lot of board meetings, some better than others. And we've seen the different personalities of the board. And today's seminar will talk about the different personalities and handling them. And there was a discussion prior to everyone getting into the meeting about fiduciary duty. We are light on our PowerPoint of citation to statute, and there was this discourse that we had before the meeting that you could hear us. We think that our clients probably latch on to some of the statutes as far as fiduciary duty a little too closely. So if your heart is burning about a citation to a certain statute, we're happy to look that up for you and find it. And statute books from our office are going to be updated and sent out once we get them printed. The legislature was late in getting all the amendments, all changes to the law finalized. And so we're sorry for the delay. We're not going to take full responsibility for it, though. Anything burning today that anybody really wants to learn about that I should know? You can always drop it in the chat too. I guess without further ado, we'll start our presentation, 10 Things I Hate About You. Just so you all know, the movie 10 Things I Hate About You was also loosely based on Shakespeare, How to Tame a Shrew. And so that's why it's called 10 Things I Hate About You, How to Tame the Board of Directors. So as I told you, this is a hypothetical, and I'm going to share. Let's talk about the hypothetical in total, the broad strokes of this. 5-member board, like I said, Padua Homeowners Association. I'm going to share screens here and the handout. I really hope some of you have watched this movie because you'll laugh about the hypothetical. So Cameron, a new homeowner in Padua HOA, recently joined the board and is getting to know everyone. He has never served on the board, and he doesn't even know what the CCNRs or governing documents are. Cameron is offered little guidance from Miss Perky, the community manager. She is too busy with writing violation notices and managing her other properties. Cameron's new best friend and former director, Michael, is there to warn Cameron about the other directors, particularly the popular and know-it-all board president, Bianca. Bianca often holds parties with a couple of other directors where they discuss the HOA's business. Michael has been ostracized from Bianca's social group of homeowners and removed from the board after several rants about pending litigation on Facebook and Nextdoor. Bianca's sister, Kat, is also on the board. The homeowners do not like Kat because she is rogue and always disagrees with the majority of the board. Kat hates Joey, who served on the board since the community transitioned from developer control. Joey is a bully scheming behind the scenes to hire his friends and win over Kat's sister, Bianca. Meanwhile, the other senior director, Patrick, is caught up in the middle. Patrick understands why Kat doesn't want to be a director anymore and tries to bribe her into staying on the board by buying her a guitar. Kat writes a poem to Patrick about the HOA and summarizing her bittersweet time serving on the board. So those that you haven't watched the movie, 10 Things I Hate About You is actually a poem at the end that is shared. And I made a poem that I will share at the end with you about the board of directors. So let's talk about this hypothetical. This handout can be emailed to you too if you can't grab it off the chat. All right, 10 Things I Hate About You. So here's a presentation overview. We'll talk about the typical bad actors on the board, illegal meetings, disclosing confidential info, chaotic meetings, security and weapons, your conflicts of interest, removal. There is a statute. We're not going to talk in detail about the removal statute, but we'll talk about it in general. Board code of conducts. We get asked about a bunch. Social media policy. That of course has been very, very on point during the pandemic, where a lot of people are just having conversations on social media. And so 10 Things I Hate About You. So let's talk about Cameron. Anybody recognize this actor? A new homeowner in Padua HOA. He recently joined the board. He has never served on the board and doesn't even know what the CCNRs or governing documents are. Does anybody know what duty fiduciary duty we're talking about that requires board members to actually read their governing documents? Nobody speak up at once. There's only 2 fiduciary duties, so you can guess. This is why I don't like Zoom, because everybody is so shy. Nobody wants to get off mute and then say, so there's 2 duties, right? The duty of care, the duty of loyalty. The duty of care is that you guys, as board members, you got to read your packet, preferably not right before the meeting, ahead of time. It's good that you would know in general what your governing documents do, although you don't need to memorize it. Rob, do you have anything to add on that?
Yeah, it's the citation is ARS 14-13115. That's the Arizona statute in the Nonprofit Corporation Act. It's defined as, the statute throws a third one in there. The duty of care, the duty of loyalty, and the duty of confidentiality is what the Arizona statute adds. We were discussing earlier that we think confidentiality is part of the other one or both of the other duties. But just throwing those, and the other thing we were discussing is just throwing those words out there is, duty of care. Well, what does that mean? I mean, you spend entire years in law school on duty of care, and what that is. There's the standard of care, what actions breach the standard of care. They are things that arise out of tort, which is what negligence is, and are pretty similar to negligence. So what Christina was describing, by not knowing your documents and acting inconsistent with the documents, could be interpreted to be a breach of the duty of care.
But it's okay to be a newbie director. So I hope I didn't scare anybody who isn't a seasoned director. Part of your duty of care is relying on people to give you good opinions, whether that be your professional community manager, whether that be your lawyers, whether that be your accountant. You can fulfill your duty of care by reasonably relying on expert opinions. So it's okay if you're a newbie. You probably, your first question should be asked to your community manager. And of course, we encourage directors and managers who are getting continuing education credit today to go to things like this to learn about running an HOA and HOA governance. That's part of your duty of care. So I think that's a good segue into the next character. So you have the newbie director, one of the directors, and you have, of course, your community manager. Miss Perky, the community manager, she's too busy with writing violation notices. So in the movie, Miss Perky was the school counselor, and she wrote things that I can't talk about on Zoom. You should watch the movie. But so I thought it was a good segue into community manager. Normally, and good community managers, which I'm sure there's a bunch of good community managers attending the seminar today. Your community managers are professional. They have certifications for HOA. They obviously have in the trenches experience that it's okay to rely on. Community managers sometimes don't have all the answers. Sometimes they have to go out to the accountant or someone else. You wouldn't ask Rob or me about landscaping. That would probably be a breach of fiduciary duty, because Rob and I don't know a thing about trimming trees or that some of the sort. Well, we might know enough to be dangerous, but certainly not enough to advise you about taking care of landscaping. So
you ask the proper professional. Some questions are for an accountant, some are for a landscaper, some are for an attorney, some are for a plumber, that sort of thing.
The reality is, with community managers, they have multiple properties, and they're very smart in the sense that, and they're very smart about different types of properties, right? Condominiums versus planned communities, and not all the same laws apply to different communities. And of course, you all have all kinds of different documents. So your community manager is going to be your first resource for getting information, for especially newbies like Cameron here. So let's talk about the president. So I won't make anyone raise their hand of who's the board president on attending the seminar, because I'm sure you're super popular, but you're not a know-it-all. Board president is a tough job. obviously you're tasked with running meetings, with chairing meetings, and you are usually the point person between the manager and yourself, and you have a lot of inherent authority to do things. What are some other roles that, Rob, that we would expect the board president to do?
Sign the contracts. They're kind of the mouthpiece a lot of times, but summarize what the board would want, take things back to the board that require the entire board to act on.
Board presidents, if you look in your bylaws, the board president's roles are normally are enumerated in the bylaws. It has a list of all the things that the president does. The vice president fills in for the president, if the president is not there. How involved the president is different on depending on the culture of a board, and also a manager too. Some are obviously more hands-on than others. Some are maybe too hands-off. I feel there are different styles of management companies too. As you might know, some management companies prefer of a more, the board sets policy and lets the manager execute everything, and then other boards where the president is really hands-on. So I think it just depends on the type of community and how you want to run things. There's different strokes for different folks, right? But hopefully you're not the party girl. I think in the hypothetical too, let's get back to this hypothetical. Bianca was holding parties with a couple of directors where they discuss HOA business. So I hope that raised some flags for some of you. I'm not saying that you can't go out to the restaurant or a local watering hole and be social, especially now as things have opened up. But I am saying here this should raise an eyebrow about open meeting law and discussing HOA business outside of meetings. The statutes in particular, both the Condo Act and the Planned Communities Act, says that there's presumption that meetings should be open. And if you don't have open meetings, what's the consequence, right? You are most likely going to be accused of withholding information or not discussing or not getting valuable input that you otherwise would get from the community. So there's only a few different categories where you could have closed meetings. You certainly shouldn't be holding board meetings at random parties, as Bianca does in our hypothetical. Rob, the open meeting statute, what are the, and I'm going to quiz, and unless none of you want to volunteer for answering, let's talk about the categories of closed meetings under the statute.
You want me to go into the executive session?
Yep. So closed meeting is the same thing as executive session. We all know that if you get advice from Rob or me or any attorney for that matter, it needs to be in executive meeting, right? We're not going to talk about what our attorney tells us what to do. That's privilege, and the only people that can waive privilege is a majority of the board, right? So as a director, if you're a director listening on this, please don't go share anything that you hear from your attorney outside of the board or your manager. In fact, you shouldn't even be sharing it with your best friend, your mom, your wife, your husband, your girlfriend, your boyfriend, whoever it is. Even if they're close to you, it is not appropriate, and you shouldn't be disclosing confidential information, right? It goes back to that duty of loyalty, duty of care.
So there are only 4 exceptions under the law for an association to go into executive session. Other than that, every decision, including deliberation, held by the board should be in an open meeting before the members, where the members are entitled to be heard. They're not entitled to vote on board actions, but they're entitled to be heard. And the 4 exceptions are legal advice from an attorney, pending or contemplated litigation, personal health or financial information about an individual member of the association, matters relating to the job, or that was 3, matters relating to the job performance, compensation, health records, or specific complaints against an individual employee of the association, or an individual employee or contractor who works under the direction of the association. And then 5 is discussion of any member's appeal of any violation. Those are the only reasons why a board should go into executive session.
So let's just say that this board really is not happy with Miss Perky here. She's not the community manager. She's not giving good service. She's writing everybody up for their trash cans that she doesn't like, and she's paying attention to all of our other properties in our portfolio. So we're going to talk about Miss Perky as their community manager and her performance. That is something that would be appropriate for executive session. It would fall under that exception.
Yeah, the
Unless you-
statute's been changed on that to include independent contractors, the statute says an employee of a contractor of the association. That's clarification. I don't remember which year they amended that, but there was disagreement between attorneys whether it included independent contractors or not, and now the statute's been clarified.
I think we've broadly always interpreted that if we were going to trash talk, whatever vendor, I'm picking on Miss Perky here as my hypothetical. But by the way, again, none of these characters are based on real people, so nobody should be offended because I am not talking about you today. Okay, so now we talk about Michael. Michael has been ostracized from Bianca's social group of homeowners and removed from the board after several rants about pending litigation on Facebook and Nextdoor. So, as an attorney, I really think Facebook and Nextdoor have been just counterproductive for certain disputes. I think Facebook and Nextdoor are great about getting people together for potlucks, for birthday parties, social interaction. They've been great in mobilizing for volunteering to help an elderly person clean their yard up, those types of things. But in general, when you're talking about really contentious issues, particularly issues that have legal problems, Facebook and Nextdoor are definitely not the right forum. You could be accused of having an illegal meeting, violating open meeting law on there. And it's amazing what people put on Facebook and Nextdoor without any filter. We had a director a few years ago that got mad at someone for an Airbnb and told everyone on Facebook that it was a house of prostitution, which of course enraged the other directors and enraged people in the community. And it was not a good scene when we had to walk it back and apologize for it, particularly in that community that didn't have any rental restrictions whatsoever. So talking about any pending litigation is particularly a no-no. I caution you, if you are a director or even a community manager, just let's be careful with encouraging directors for Facebook and Nextdoor. I'm not saying that you can't have your own personal Facebook account and share all your memes. In fact, I was off Facebook for 2 years and had to get back on because I was missing all these social invites for dinner from my friend. So I'm not saying that this thing doesn't have a great function. It just doesn't function well in terms of operating an HOA, because we have open meeting law to conform to, and we are running a corporation, and business needs to be conducted at a meeting that's properly noticed. So I know that many of you are veterans here. You know that board meetings need at least 48-hour notice, conspicuous placing, or reasonable means, determined by the board. So social media has its pitfalls. You want to add anything to that, Rob?
Facebook is the devil. I don't know. Yeah, that's yeah. I'm not a fan of those things, but I think you put it pretty well. Sometimes when boards, okay, here's something to add. Sometimes when boards or communities get in trouble or have a problem, or this kind of gets out of control, as your lawyers, we can assist with that and draft a social media policy, and it's a confidentiality policy for board members, so that communications is proper and should be channeled the right way. And when one thing I was kind of thinking about when we were talking about fiduciary duty is, if you do get into trouble or there is litigation, you can, as an association, and you're supposed, and board members, you're supposed to be held to a higher standard, and people get really upset and punish you and find sympathy for the other side when they might not have otherwise if you violate these fiduciary duties and these duties. So it can end really badly, and a little thing or good intentions can really turn wrong by not following them.
Interesting point too. I often get the question of, so we adopted this code of conduct for the board or social media policy, Rob. Do the directors have to sign it?
Yeah, well, are you asking me or
Well, yeah. I mean, I obviously the answer is there's nothing in the law that makes you sign it, although the law already applies to you as a director. For those of you that are directors on this call,
yeah,
the law applies to you. A code of conduct does nothing but remind you of what your duties already are.
and then the other problem is if you get a board where, let's say, all 5 members sign it and they all are harmonious together, then you get a new board member that's like, oh yeah, I don't have to sign that, I was elected, who cares. So then you get other board members that have signed it and some that haven't. So I mean, those are issues.
And it's funny because for those who haven't signed it, even though they're not required to sign it under the law, it doesn't look good to the other, especially to the members who say, well, the rest of them agreed to play nice, but you didn't. So I don't know. I wish I had better news for you on the whole code of conduct. I think they're still a good idea. I think they're a good reminder. I think anybody that has good intentions, obviously, if you have an agenda, uh, a certain agenda, a nefarious agenda, your own self-interest, you shouldn't be on an HOA board. HOA boards and fiduciary duty is about doing what's in the best interest of the association, even when it's against your own personal interest, right? The common example is raising assessments. You probably don't want to spend an extra XY dollars a year, but you know that the community needs the money for whatever maintenance components it has to perform. Yet, you vote against it because you don't want to pay that money. That's different especially if you know that the association needs that money for its budget. So let's talk about do you have something to add?
Not me.
Okay. Let's talk about Kat, the rogue board member. This is the board member that just wants to disagree with anything. If they vote yes, then everyone else, then she's voting no, or he's voting no. So we have Kat. In the movie, Kat was also the one who didn't want to conform, by the way. And she was considered rogue and the shrew, as Shakespeare put it, taming the shrew. I would hope, especially in this climate after COVID or during COVID, that we understand the ability to civilly disagree. We agree to disagree. Unfortunately, after many directors who disagree, they don't do so gracefully. They go out and they undermine decisions of the board. That's actually a breach of fiduciary duty, your duty of loyalty, by undermining decisions that the board has made. So, Rob, I know the rogue director was something that you put down. Do you want to talk about your rogue director and?
I mean, my notes for this is dissent is okay. I mean, disagreeing is just fine. But there's things that aren't fine. Ignoring board decisions, acting without authority of the board, giving out information, confidential information, executive session, and giving out misinformation or painting your own picture. Those are the things. Disagreeing and saying, yeah, I think we should do this thing differently or this other thing, that's just fine. That's why you have multiple directors, that balances out that kind of thing. But there's a difference between disagreement and wanting something else or wanting something done differently than what we're talking about the rogue board member and breaching confidentiality and acting without authority and not making decisions without that the board should be making, without taking them back to the board, that kind of stuff.
Often they're not separated, but closely is the rogue one may or may not be the bully director, the one who's always scheming behind the scenes, the one who calls everybody ahead of time to convince them that their side or their choice is the right choice. I discourage that type of behavior in the sense that it's better to have a discussion with everybody to input all at once, and see what the climate is. And so this bully director here is Joey. In the movie, Joey was a bully too. Bully directors sometimes can be hard to deal with, especially if they're railroading people into to voting a certain way or the other. I always remind people you have the same goal in mind, right? You want it to be a nice place to live. You want to increase property values. Um, the hypothetical here discussed about Joey in the context of the declarant. The declarant and developer, we use those synonymously here in this context, has different issues that come up. Rob is more familiar with declarant issues and is litigated a lot more in that arena. Rob, what are some of the pitfalls that you have from developer boards?
Well, I mean, there's the fiduciary duty issue, that the developer doesn't pay assessments. They start paying for marketing assessments out of the HOA's budget. They leave an association underfunded with zero in reserves. They don't finish parts of the project. They leave parts of the project unmaintained. They don't turn over documents that they should. I teach an entire course, and you can email myself or Christina for a thorough checklist to go over during the period of declarant control and turnover. But you know, little things like not knowing who or not knowing where your plans are for certain things when you go to make repairs or maintain something, rather than spending, you know, just a couple of $1,000s on components, it could be tens of thousands of dollars because you have to employ architects, engineers, or other design type professionals to work on the component. Now, the more components an association has, the more problem that is. But the documents that you obtain, I mean, there's a lot, and then it's not just getting the documents, it's auditing them and understanding what's best for the association, because what's required or what was decided on by the declarant, you know, when think of insurance, for example, they might have said, well, you know, we have the commercial general liability insurance for the, you know, the construction company, the developer, we need minimal insurance, and that might not be enough for the association. Or they may not get insurances that basically you're required by fiduciary duty, or potentially even your documents, your CC&Rs, like fidelity insurance and stuff like that. So they it's not just getting the documents, it's having an understanding of them and auditing them and knowing what they mean and passing them on to future boards.
Remind us what the statute of repose and explain that to everybody.
Well, for claims against the declarant or the developer, there's a couple of different types. One are financial claims, and those typically aren't covered by insurance. Whether there's a, you know, whatever the statute of limitations is for those, and I'll tell you in a second, but you want to catch those as quickly as possible, because even if they're within statute of limitations, when your project is developed, typically a developer, we refer to as a single asset LLC, where they build the project and then they wind it up and they disperse everything as profit and loss, and then the only asset that's left is insurance. So if you have a claim that's not that is a financial claim or fiduciary duty or some other claims, you want to catch those as quickly as possible, at or before or as quickly after turnover. For claims that cause damage or there's a loss, as defined by an insurance policy, then, you know, if they're brought later, that's okay, but then you have to refer to the statutes of limitations. Basically, and there's more complexities on these, there are 2 years for negligence claim. The shortest is 1 year for consumer fraud. They're 4 years generally for breach of contract or contract based claims. And then construction defect or implied warranty, it's ARS 12-552. There is 8 years from completion, potentially as long as 1 year from that, or 1 year in additional based on discovery. So if you did I say 8 years?
8
Is what I
years.
should have said if I didn't say 8 years. So it's 8 years, but if you discover it during that 8 year, let's say you discover it 6 months into the 8th year, you may have as long as 6 months in addition, as long as 1 year, if that makes sense. So it can extend a little bit beyond the 8 years for things discovered in the 8th year. Those are, and the reason for the longer statute of limitations is, and it typically comes up in construction components, is you may not know a component has a defect or a problem because you may see no signs of it, or you may see very little signs of it. So that's a longer statute of limitations, and it's actually called a statute of repose because it's not just based on discovery, where like negligence is from when you knew or should have known, and that can extend that a little longer. But those are the general 2 years for 1 year for consumer fraud, 2 years for negligence, 4 years for statute, and as long as 8 years or the potential tail for construction defects.
I was just reminded that we have to do a code for continuing education credit, so to prove that you were here. So I'll give out a code that is related to the movie, and it will be Julia Stiles. It's in the chat here. A couple of questions in the chat for those of you on the line weren't able to see this. Someone asked about the frequency of meetings. Some bylaws will say that directors need to meet a minimum amount of times, or some will say they need to meet every month. Most bylaws don't set a minimum number of board meetings. If you have a lot of business, then you might need to meet more frequently. If everything's running smoothly, I know some associations that cut it down to quarterly. You're going to have to meet if you have landscaping contracts and other decisions to make for sure. So I wouldn't put off meeting, but obviously you don't want to just meet to meet, and you should talk to your manager about what's appropriate. There's another question here. My association chronically refuses to have board meetings. The last had board meeting in May 2020. There are lots of problems. Okay, is there a question in there? I will say that it's a problem if they're not having business without meetings, right? Because the whole point of open meeting law is for homeowners to be able to comment on board decisions. So if a board is making decisions such as hiring a landscaper or hiring a different contractor, then there needs to be a meeting. So I'm going back to our little hypothetical here. Patrick is the board member that gets caught in the middle of everything, and he is the swing vote, you should say, of the 5. I talk about him trying to bribe everyone with a guitar. Obviously, you probably shouldn't be giving gifts in order to sway votes on the board. It might be a breach of your fiduciary duty. Julia Stiles is the code for anybody who missed that.
That's for people that need it, that are for
credit
for their professional certifications.
So I did one slide here about, so we talked about taming bad actors. So inflaming bad actors is the opposite. And these are just several ways that we all know don't work very well when you keep things personal. When you lose your cool, as my dad says, you lose. So calling people names, insults, threatening them, letting your emotions take over usually end up blowing up, and it might be better just to let things cool down or have a different person to deliver a message. Again, as for those of you who've had me in seminars before, it's not necessarily about what you say, it's more about how you say it. 90% of fights are about how you say things and not the actual substance of the issue. We also see this whole standing on principle a lot with board decisions, such as, we don't like what our landscaper did, so we're just not going to pay him at all for that last month. And instead of firing them and just finding a new landscaper, they they just stop paying them. You can't do that. You're obviously bound by a contract, and it's probably more money to litigate over that last month of paying the landscaper and firing them. And so you don't want to go down the whole principle of the matter road. Anything to add on that, Rob, on my last slide of inflaming bad actors?
I don't, you mentioned listening. I think a lot of times when you listen, you understand, a lot of times they'll give you the weaknesses in their argument, or something that you can catch onto as to why they're not right, or why your side would legally prevail. So I think listening is important. I think you mentioned that.
Well, and it leads me to this next slide. At the end of the day, removal of a director is actually a very hard thing to do. Here's the statutes. I did include a couple statutes here. The first one, anything in the 18s is a planned community. Anything in the 12s is a condo act. They're very prescribed statutes on removing directors. And so whether you like it or not, unless the very large percent of the community is going to rise up and actually vote to remove someone, you're going to have to play nice with them. I encourage you to take a look at the statutes. Is there anything you like? The statutes prescribe a certain amount of people that have to sign a petition. The petition has to be sent to the board, and then the board within 30 days has a recall election. I've seen a lot of recall elections in the last year, for better, for worse. They're expensive. They often, unfortunately or fortunately, however you want to think, they require, or sometimes require, they don't absolutely require legal oversight. Many times the management company gets gored in it, has nothing to do with the politics of the board. And people, for some reason, well, the management company works for the board, it works for these directors, and so they want outside people to oversee the election. I don't know of any management company or any manager that's going to risk their credentials to try and rig an election. Election materials, particularly, are available for inspection. These materials are kept for a year. Elections are somewhat hard to fudge, right? Secret elections are trickier, but for the most part, especially in non-secret elections, you have people sign ballots, and this is not a presidential election where you have thousands of people in verification. This is usually a few hundred, maybe a few thousand for bigger associations. And so rigging a HOA election is a lot harder to do. So Rob and I oversee elections. We do a few big ones per year. We have one that's secret. It's a few thousand, it's mixed use, and it's cumulative, meaning you can put all of your votes on one candidate or another, and those make our head explode. And it is kind of somewhat treated like a presidential election, where we go and we can get verification. If you think that an election is going to be contentious and there's going to be challenges, then I would encourage you to spend a few $100s to go out to your council and have them look at the election materials, or even engage them for a limited representation to oversee the election. It's usually far more expensive to redo the election than it is to spend a few $100s on the front end of making sure your materials are correct and are being sent out within the right time frame with the correct notice. So everyone who knows me, I'm the one with the sharp edges, and Rob is the one who doesn't have sharp edges, and he is really a better person at mediation and negotiation and talking about these tactics. Have a way, Rob, because I don't pretend to be an expert on this one.
Okay, what I want to give you guys is some of an idea and introduction on what lawyers do for mediation and conflict resolution, and also then to talk about negotiations. And it's kind of giving away a lot of secrets here about how lawyers get cases resolved. And I've resolved some very large and very complex, and sometimes they don't need to be large to be very complex, and sometimes the large ones aren't as complex. But I've resolved some very large cases in mediation, and I definitely believe in mediation. And so here's a couple of things that lawyers do for mediations and conflict resolutions. Christina already kind of started to get into them. keep your cool, don't get sucked into that name calling, over talking. I always say for community meetings, what I always tell people is, managers and other owners can say, well, God, how can you even listen to that guy? Well, I think anyone that, number one, they're a stakeholder. They own property, and yeah, sometimes they're absentee or they don't live there or they have rentals or whatever. But and then number two, they care enough to go to their community meeting and talk about their opinion. So they and under the law, they do have the opportunity to be heard. So I think you need to listen to all voices. Whether or not you agree with them is you could completely disagree with them, but you should have some patience and listen, which is one conflict resolution tip. Keep your cool, listen, understand.
What happened?
Unmute yourself, Rob. I accidentally muted you. Go
Oh.
back.
I was like, how did that happen?
Yeah, that's my fault. Rob, unmute yourself. I do like, while we're waiting for Rob to figure out how to unmute himself, I do like that Rob sees the silver lining for people just having enough passion to show up and care about their association.
I think I'm unmuted now.
You are unmuted now. I'm sorry. Go back to your part of your tips.
Listen, understand the conflict. Like I said, a lot of times you see the weakness in someone's claim, or they tell you themselves why they can't have what they're asking for, or that it's impractical or something, or they'll admit it. You can say, well, you admitted it yourself. Communicate, open the lines of communication, and this is something, these are all kind of, or a lot of them are tips from mediation, but set the stage. Say, hey, we can get mad, we can play the blame game, we can talk about the past all you want, but if we're going to resolve this, we've got to put that aside, and you've got to talk about resolution. Focus on the resolution, focus on what each side wants to accomplish. And I refer to it each side, there could be many sides. Be solutions based. Outline the areas of disagreement. In other words, well, we agree on several things, and A, B, and C, whatever call them, and D, E, and F, we could probably do business on, we're open to, but G, H, and I are just, kind of, deal breakers. And then whatever order you approach them in, it's usually what you agree on. But sometimes you use the middle grounds as a bargaining chip for saying, well, you've got to put this one or two things aside because the association just can't do that, just can't accommodate it. So, look for solutions that are acceptable to everyone, and try to narrow the area of disagreement. Involve a third party, involve a lawyer, involve an expert, whatever field it is, involve a mediator, explore alternatives, don't postpone, and don't put it off. Now that's contrary to a negotiation tactic, where sometimes where I'll tell you in negotiation tactics to control the flow of information and to control the pace of information. Don't let that guy that emails you back a second after getting your email, don't let him take up your entire day with the banter. Control the pace of the discussion.
Rob is one of the best people I've ever seen at that. I will get an email back and I'll be in my office hot, screaming, really annoyed because I get like a 5-page email from one lawyer in particular lately. And I'm like, Rob, just deal with this. He's like, guys, just wait. You don't have to email him back. He's not your client. So you're right. Now the sky's not going to fall just because you have an unanswered email for more than 24 hours.
Yeah, young lawyers kind of get sucked into that, where they operate on other people's pace, and some people, that's their tactic, that's their escalation tactic. But the last kind of big tip for the mediation, negotiation kind of thing is realize the economics of it. A lot of times people want to stand on principle and say, well, this is right, this is wrong. And, you know, recognize economics of it, recognize the cost of litigating. And, you know, sometimes that's in your favor. Sometimes you're the, well, you know, hey, is this guy going to spend $10,000 litigating his $300 issue? Or, you know, so recognize the economics of it. You can accept some responsibilities, but again, focusing on the past isn't that, you know, it's not going to get anything accomplished. Sometimes people just want to get it out and be heard. So, you know, maybe in some instances it does. When lawyers mediate, we call it informal because it's not binding. In other words, you're free to speak. You're free to say, well, you know, if we can do this, we could resolve the case, or if we go down this road, and that encourages that kind of discussion. A mediator normally brings everybody together and kind of cuts out that kind of discussion, and it kind of can be the shoulder to cry on for telling your story, for doing that, you know, getting everything out and blaming the past or whatever one or both sides wants to do, but then they kind of get everybody together. If you're going to mediate, and you don't just have to have a lawsuit, you can use your lawyers to do that. One of the professional associations for community managers has a free mediation service. So the first step for mediation and bringing the conflict together and resolving is preparation. You want to, and lawyers do mediation briefs. Doesn't necessarily have to be that, but you know, prepare. Think of the other side's arguments. Think of your side's arguments. Think of what you want to get accomplished. Think of solution-based. Also, another thing to consider is what's going on behind the scenes. For lawyers, a lot of times that means the insurance carrier. And you've got to do what the insurance carrier is going to need to, you know, whatever side you're on, either pay the claim or, well, generally pay the claim or accept coverage or something like that. But think about what's going on behind the scenes. Like for homeowners, well, is this person selling their home? Do they have rentals? You know, consider that. Posture the claim to settle, posture the issues to settle, do everything you can in preparation. Prepare your talking points. Don't give away the farm, but also know when to, you know, make a real offer or make a real move or do something significant that the other side wants that you don't necessarily want to do. Think of what each side wants, see that path to resolution. That's kind of, I try to summarize the mediation and conflict resolution. And then for negotiation tactics, I mentioned bold moves, but I've heard a lot of lawyers say the first person to make the first person to reasonable land generally wins. Because if you're way out here and this guy's way out here, it's like you're never gonna close the gap, and you look even more unreasonable. Whereas if you recognize the claim and recognize that there's merit, and you're the first person that puts that reasonable offer on the table or offers something reasonable, a lot of times you have the power in the negotiation. So consider that. Consider your own priorities. You know, sometimes you're fighting over something that, yeah, it wouldn't really hurt all that much if we did that anyway. Make your offers reasonable. That's kind of we talked about that. Factor in the risk, factor in the cost if this goes to the next step. And everybody, you know, likes to throw out, oh, lawyer, sue you, whatever. Sometimes getting a lawyer involved is the best thing because the other side's being reasonable or doing something reasonable. Let's see. Outline your claim, put it in the light most favorable. Outline your evidence. Back to the offers. A lot of times, I have clients we're in a mediation where there's an offer made, another side makes an offer, and then it's where do we go from here? Well, you've got to consider where you want to go. or where you want to get to. And a lot of times from the very first offers, you can kind of tell what the value of the claim is and where it's going to end up. And well, there's a mediator, I think Dave Dameron is the mediator, that calls it the dance of symmetry, and it's been used a lot, the dance of symmetry. So if you start, if one side makes an offer here and then the other side makes an offer, you look at where the middle is, and that's generally where the negotiation will take you, or one or both sides will try to drive it there. So consider the dance of symmetry. If if one side starts out at $80 or $800,000 and the other side starts out at a million or $100, 90 is the natural middle. So consider that, and consider that in making your any kind of counter offers, and as you move back and forth. The other thing is the last effort, and a lot of times it's called split the difference. When you get close and both sides kind of seem at their walk away. When I'm a plaintiff's lawyer, which I frequently am, a lot of times I'll say, well, where, and it's usually money you're talking about, not always though, especially with homeowners associations, but when it's money and you're working on contingency fee, a lot of times I'll say something like, I will, on this last $50,000, I will not take a fee on it at all. And I will reduce my fee. If they'll pay that, we can settle the case. If not, we got close, but we can't settle the case. But do those kind of last things where you, these are negotiation tips, where you do your last negotiation, where something you want, you can dig in for it, or you can ask for it, or you can, do whatever you can to get that last bit. Understand the value of a walkaway, when to do it. Timing is very important for negotiations. A lot of times, the thing that settles the case for both sides, when it just neither side would be open to it in the beginning, but after a year of litigation or spending some money or something like that, a lot of times they're willing to do that. So understand the timing and always factor in the risk. Don't go off of emotion and don't go off of principle. Understand that it's gonna hurt both sides to litigate it, spend money, motion practice. A lot of I've heard a lot of good mediators say, well, it's not a settlement of a any kind of matter with any kind of complexity unless both sides kind of grit their teeth, and it kind of hurts a little bit for both sides. So understand that, and understand that you may be willing, may be necessary to do that to settle the claim. Those are my mediation, and I kind of lumped them both together and kind of went from one to the other, but those are my negotiation and mediation tips.
Thanks, Rob. I'm gonna we talked a little bit about policies, code of conduct, so I skipped those slides. Attorney involvement, when we were talking about board of directors, Rob is very good at negotiating things. It's great when parties can work things out on their own. Sometimes you do need an attorney to help work things out. Certainly demand letters to stop behaving a certain way. Those can be embarrassing. They often work. Acting as a mediator, and sometimes you just need I like to call this a high price babysitter, and keep people honest and just advise them what the law is, and so you can just get through your chaotic meetings. I did a seminar a few years ago. Understand that if you do not want weapons at your meeting or anyone to bring weapons, you have to post certain language saying that people cannot bring in weapons. If you think people are going to bring weapons and that's uncomfortable for you, you certainly can hire an off-duty police officer or some type of security to go to your meetings. We have seen that, unfortunately. The beautiful thing about Zoom and virtual meetings, you can't shoot somebody over the internet. There's going to be no physical altercation by having a virtual meeting. So I'll give you one last code for those of you that need for credit. I will, let me type it here in the chat and tell you. It's going to be actor Heath Ledger for the second code. And then I will take questions if there are any. Let me leave you with a parting poem, since there was a parting poem in 10 things I hate about you. 10 things I hate about the board. I hate the way you stalk me and the way you bully me and treat me unfair. I hate the way you look at my trash cans and weeds. I hate it when I get violation notices that make me swear. I hate your social media posts and the way you can't make up your mind. I hate you so much it makes me sick. It even makes me rhyme. I hate it. I hate the way your community manager and lawyer are never right. I hate it when you lie. I hate it when the budget makes me laugh. Even worse when the assessments make me cry. I hate it when you meet in secret and the management never answers my emails or calls. But mostly, I hate the way you ask me if I'm interested in staying on the board. Not even close, not even a little bit, not even at all. So I hope that we haven't scared you to wanting to be on a board. I think that the majority of board members, that especially ones that attend our seminars, they're looking not to be the people that we talk about at our seminars, right? And if you're not expected to know everything. You certainly have your professional management to rely on. Managers, most of these management companies and your bosses have a wealth of experience and have been there, done that. I've been in the industry for 30 years and have seen most everything. So there is a wealth of information within our trade groups, within the owners of our management companies, for our managers themselves, accountants, all these vendors. So there's someone to help you if you don't know the answer. And there are certainly ways to get along and respectfully disagree. I answered some questions today in the chat. There was one about agendas. Understand you need to provide agendas at the meeting. You don't have to provide them in advance under the law. I've not seen it where a director or a president in particular has refused to discuss an agenda item. I would think that a majority of the board could overrule them and still discuss something on the agenda, even if the president doesn't want to. So with that, is there any questions? Please take yourself off mute. Let me know now. And certainly you can email me too. I hear nothing. Well, thank you for joining us today. Let's see. Someone asked if an open discussion, I missed the agenda, or in the open discussion. Oh, I will say that the question about the agenda too. I've also said that if something is not on the agenda, there's normally a homeowner forum where someone could, technically in their capacity as a homeowner, not just as a director, bring up something that they want to discuss. It obviously wouldn't be something necessarily appropriate for a decision, but could be discussed. Thank you so much, guys. Please go watch the movie. I think it's interesting and you'll get a good laugh at it. If you need, look at Terry. If you need CMCA credit, please email Terry Rodriguez and make sure that we get you the credit that you just gave up your hour of your life for. So